Now, today when jury instructions were finalized, this is the problem. This is the problem right here. This tweet specifically has generated a lot of buzz because this thing doesn't smell right. Today, when jury instructions were finalized, the judge ruled that Adam Waldman's 3 statements, the sources of Heard's counterclaim for defamation against Depp, will be considered as Depp statements under the theory of principal agent, a win for Heard. This tweet is almost certainly wrong. Now, I'm not in the courtroom. LawTube isn't in the courtroom. Chanley Painter's in the courtroom. But let me briefly talk about what this means. Okay? Ignore what she says for a minute. We're going on law lesson time. Okay. So a principal agency relationship is similar to an employer-employee relationship, right? So if you are an Amazon driver and you're driving your Amazon truck and you run over a bus full of school children while you're on your delivery route, that's Amazon as the employer. You're the employee. You're in the course of your duties, and therefore Amazon is likely liable, whereas you might not be. And you might also be liable, but Amazon absorbs that liability as the employer, or as it were in our analogous sort of understanding as a principal. If Johnny Depp has employed Adam Waldman and instructed / authorized Adam Waldman to speak on behalf of Johnny Depp, to be a spokesperson, to be a mouthpiece for Johnny Depp, then Johnny Depp becomes the principal and Adam Waldman becomes his agent. And the agent's actions are the principal's actions so long as they are within either the express or implied authority of the agent. So Johnny Depp has to either expressly or impliedly confer the authority to speak on his behalf to Adam Waldman. Now, you may ask yourself, is a lawyer speaking on behalf of their client? Often, yes. Always, no. For example, when Akilah the Bee sued Sargon of Akkad, right? She served Sargon improperly. Sargon hired an attorney to appear in court for the limited purposes of responding to the failure to issue a proper summons from Akilah. He did not authorize at the time that lawyer to accept service, to make public statements, to do anything other than make this court appearance and make the argument that he was not properly served. He actually did not even authorize him to consent to the jurisdiction of the court. This is very, very critical because if he did, then that lawyer could have consent to the jurisdiction, and then the service wouldn't matter. But he hired him for a limited purpose to do this. Now, Sargon would ultimately authorize that attorney, I believe it was the same attorney, to accept service, and they would go through the process. He would ultimately win that lawsuit. Great lawsuit for YouTubers, by the way. But that's how that worked out. All right. In this case, we don't know the extent of Adam Waldman's authority of representation for Johnny Depp. Now, how do we suss this out? We saw how they tried to sort this out by deposing Adam Waldman. And Elaine asked him question after question after question, trying to get him to admit that Johnny Depp had given him authorization to speak in public. Now, Ben Chu was very quick, instructing him not to answer any of those questions because it would violate Ben Chu's client, Johnny Depp's privilege. The privilege holder is the client in an attorney-client relationship. If I am your attorney, no matter what I want to say, you hold the privilege and you can stop me from saying it. And if I violate that privilege, Big, big bad problems for me. I could be responsible for all of your debts or whatever, that are caused. Any damages, you would have a claim against me for those damages. Okay. So Johnny Depp hires Adam Waldman. We don't know the extent, capacity. We don't know the timeline. We don't know if he was fired at any given point. We don't know anything. We have no facts in the record because of the testimony that was given in that deposition. All was protected by attorney-client privilege. So we have no evidence. So how do we resolve the principal-agent relationship? Well, they're going to hire Johnny Depp, or they're going to bring Johnny Depp to the stand, possibly, to try and sort this out. There are other ways to do this. You could bring the reporter to the stand. You could ask the reporter if Adam Waldman was speaking in his official capacity, because you have express authorization or implied authorization. In the implied authorization, if my agency law is correct, and it's been several years, but if my agency law is correct, and I think it is on this issue, the implied authorization means, does the person interacting with the agent, so not Johnny Depp or Adam Waldman, does the person interacting with the agent, would a reasonable person in that situation be able to infer reasonably that the agent had the authority to act in the manner in which they acted? If Adam Waldman's out there, hey, I'm the attorney for Johnny Depp, I'll take your questions, you could infer that he's acting in his capacity as an agent for Johnny Depp to speak to the press. However, if a journalist pops up while Adam Waldman is walking on the street and says, hey, you have a quote about you have a quote about this Johnny Depp thing, or do you have a quote about Amber Heard? And he says, those bitches are lying. Bitches be crazy making shit up. That doesn't automatically infer that he's speaking in an official capacity. Again, press release, some sort of public appearance, calling up a journalist to make a statement. Those things imply or allow you to infer that relationship. They have not yet called the reporter who's interviewing Adam Waldman to the stand. Instead, they went for Adam Waldman. They're going to go after Johnny Depp. They need to put facts on the record to do this, because principal and agency relationship is, as far as I can tell, always a fact question. Always. Which means it is not a matter of law. The judge in Johnny Depp's case is not the finder of fact. The finder of fact is the jury. The judge in Johnny Depp's case rules on the law. So the judge is not there to weigh the sufficiency of evidence. The judge is just there to determine if there is evidence that Johnny Depp could be found as a principal with Adam Waldman as his agent. Okay? I hope you're following along on this. I'm trying to deliver this in the most clear way possible without getting too far into the weeds of legal speak. But the long and short of it is, agent principal relationships are always a matter of fact for a jury or a judge in a bench trial to find. They are not to be ruled on as a matter of law. So, what does this mean? How does this jive with this statement from Chanley Shaw Painter? It doesn't. This is probably inaccurate reporting. Now, here's where we have to go. The reason this is probably inaccurate reporting is because this motion to actually exclude these statements has not been made and can't be made until Amber Heard's case in chief is finished. So this motion is not before the court, only jury instructions. So what does that mean? What is the more likely scenario here? Luckily, we have gotten it. We have gotten it from Hogue Law. Well, actually, let's do this before we get there. Let's see how we've got some mud going on. Here we go. Here we go. Pool Boy says, check it out. And he quotes my tweet. Actually, the people who watch LawTube are informed enough on the issue to be confused at how this judge would make this ruling at this stage of the case. It's more like Court TV has inaccurate reporting on the issue. That's the value of LawTube. And Chanley says, not inaccurate when we heard the arguments from the attorneys and heard the judge make the ruling in court this morning. Okay, bear this in mind. Emily Baker, thanks, Chanley. Was this regarding a jury instruction for consideration of an agent's statements, or was it ruling it as a matter of fact, taking it from the jury's consideration? Chanley says, thanks, Emily Baker. Very formal. This was a jury instructions conference. So as you know, the jury instruction was argued and decided by the judge to be included. The exact language of the instruction was not shared with those watching the hearing. So we shared what the judge said about principal and agent. Okay, now we're getting more clear. This is way, way different than the initial tweet. Again, the initial tweet is here that the judge ruled that these will be considered as Depp's statement. That's not what the judge ruled. This is definitely not what the judge ruled based on her on that tweet that she had just sent. The judge ruled that the jury can find a principal-agent relationship. Okay, so why is this being debated? That's the next question we have to answer. We have to figure this out because that was always going to be a fact question for the jury. So what are they fighting over? And what they're fighting over leads us to the actual conclusions here. Let me pull up that tweet next, okay? This is from here we go. Richard Hogue had a thread on this, and this was replied to by another lawyer on Twitter named ABG. I don't know anything about this guy, but I think he's nailed it here. Okay. He says, to be hopefully slightly clearer for others, I guess, and again, we are taking a stab at this, but it's a reasonably inferred stab from several professionals all looking at this going, this isn't where this would be at this stage of the case. All right. I guess all that happened is that Team Depp proposed the legal standards in these 2 pages of their motion for summary judgment for a jury instruction. That was denied today, the jury instruction. And then Court TV proceeded to prove why we can't have nice things. Okay. Here is, they have made a motion for summary judgment. Ms. Heard cannot prove actual malice by Mr. Waldman. So to the extent Ms. Heard attempts to argue, contrary to her counterclaim, that she is merely seeking to hold Mr. Depp liable under a vicarious liability theory, Ms. Heard's arguments fare no better. To state the obvious, vicarious liability is liability for the tort of another person. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman committed all elements of defamation. The elements of defamation are publication, actionable statement with requisite intent. Public figure must prove by clear and convincing evidence that a defamatory statement was made with actual malice. Don't worry, I will explain what's happening here. I.e. knowledge that it was false or with reckless disregard for whether it was false or not. You've heard this if you've watched my show and probably if you've watched others. Reckless disregard is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of this publication. So now we go to the next page. The Virginia Supreme Court has confirmed that summary judgment is appropriately granted against the plaintiff that fails to present evidence from which a jury could find actual malice by clear and convincing evidence. Here, Ms. Heard is a public figure and as such must establish that Mr. Waldman uttered a defamatory statement about her with actual malice. There's no evidence in the record that Mr. Waldman knew the counterclaim statements were false, nor is there any evidence in the record that Mr. Waldman subjectively entertained serious doubts about the falsity of the counterclaim statements. Again, I'll summarize this all in a second. Ms. Heard's factually empty response to Mr. Depp's fifth interrogatories is damning. She had an opportunity to explain how Mr. Depp can be held legally responsible, which requires as a threshold matter establishing that Mr. Waldman committed the tort, including acting with actual malice. She cannot beat her burden. This is an argument that is rejected because it's wrong. Okay, this argument that they put forth is incorrect. You do not have to find that the person making the statements independently came to the conclusion that they or independently had knowledge of the falsity. Okay? This is where it gets weird and why this is confusing. They have to prove that Johnny Depp, who is the principal, meets the elements of the tort, which means that Adam Waldman acting as his agent merely needs to perform the actions of the agent. But the question of the truth or falsity and the knowledge thereof goes to Depp as the principal. Adam Waldman is sitting in the shoes of Johnny Depp, performing the mechanical role of the agent. He is not granted the autonomy of making those decisions because he's acting at the behest of Johnny Depp. That's why Adam Waldman would not be held liable, but the principal would. Does that make sense? Does that make sense? So because no matter what Johnny Depp says, Adam Waldman doesn't care, right? He is just, imagine Adam Waldman is a puppet and Johnny Depp's a ventriloquist. Okay, this is the analogy I'll give you. The puppet doesn't care what Johnny Depp knows, right? It just talks while Johnny Depp is giving it the voice. So the puppet, you don't have to meet a legal standard for the puppet's actions because the puppet is acting at the behest of the master and in its full control. Johnny Depp would be the principal, Adam Waldman the agent. Johnny Depp the ventriloquist, Adam Waldman the puppet. Nailing that down is the most important part of this analysis. And if you literally think of Adam Waldman as a wooden dummy using Johnny Depp's voice, that's the theory that they are using to find Johnny Depp liable for the statements made by Adam Waldman. Now, the question is, does Johnny Depp have his hand up the ass of Adam Waldman to control his mouth? That's the jury question. That's the jury question. This is not a matter of law. The jury has to determine if the evidence before them says that Adam Waldman made those statements. A puppet can't speak on its own, right? The puppet making statements is Pinocchio. That's not a puppet. That's something else. Or if it's just Johnny Depp making the statements through Adam Waldman. Because if it's Johnny Depp's words and Johnny Depp's knowledge, then he's liable. If it's Adam Waldman's knowledge, he's not. I'm trying to cram all of principal agent law into one spot and completely remove legal language from it through analogy. All right. So again, if it's Johnny Depp's ventriloquist voice coming through an apparent mouth of Johnny Depp loves me, fuck you, right? Like if it's his ventriloquist voice coming through the puppet, then it's Johnny Depp's fault. If Adam Waldman is not a puppet, but is speaking on his own and using his own mind, then it's Adam Waldman's fault, and Johnny Depp is free and clear. Okay, so how do we prove this? Like I said, we'll go back to that proof factor. You either have to have an admission. You have to have an admission from Adam Waldman. Johnny Depp told me to say this. Johnny Depp told me to speak to the press, which you're not going to get because that's attorney-client privilege. Or you have to get Johnny Depp to waive that privilege by talking about his discussions with Adam Waldman. If he says, yeah, I hired Adam Waldman to negotiate a better wine contract and also to speak about that heathenous bitch in the press, then if Johnny Depp makes that statement, then bam, you've got it. You've got an agent-principal relationship. But Johnny Depp's likely not going to make that statement because Ben Shue will object to any question that could lead to that answer. So the other way to get it is through some third-party source. They're going to try, because they've failed so far to introduce, I don't think they're calling the reporter, which should have been the first person to give a statement to them. I mean, they should have gotten deposition testimony or noticed them to be a witness to come in and testify. Yeah, Adam Waldman was definitely speaking on Johnny Depp's behalf. I mean, I said, you're the attorney for Johnny Depp, right? You're the guy who's authorized to speak to this matter and to talk about this lawsuit, aren't you? Like, and he indicated, yeah, he could answer some questions. So I had no doubt that this is Johnny Depp's spokesman. To my knowledge, they haven't done that. So what they're going to do is try and introduce statements from within the article itself. Adam Waldman, attorney for Johnny Depp, says, is that sufficient for the jury to make a factual determination? So here's what happens next. All right. Now that we've cleared up, Chanley Painter had, and love you, girl, go kill it. Slay queen, whatever. You're doing the Lord's work, getting people to actually look at court cases, and God love you. Go do it. I don't think she doesn't know this, by the way. I'm not impugning Chanley's knowledge or experience or anything like that. I think it's the limits of the Twitter communication and just notice how long I've had to explain this, right? This is like 30 minutes. And she's trying to condense this into some concise, 200 character tweets. So I'm not picking on her here. It's the imprecision that's the problem. I don't think it's a lack of knowledge, but it could be. I don't know. But I'm going to give her the benefit of the doubt. I'm going to give her the benefit of the green shirt she wore the first day. Okay? That's what I'm doing. That being said, does this mean that Johnny Depp's statements are automatically in, or that Adam Waldman's statements are automatically in and attributed to Johnny Depp? No. Most likely not. There is there could have been some weird thing that the judge ruled on. I don't think so. Because we're not there yet. So what will still happen and what could happen from there? Amber Heard still has to rest her case in chief. Once Amber Heard rests her case in chief, Johnny Depp's team will likely make a motion to strike the same way that Amber Heard's team made a motion to strike when he rested on his case in chief. Okay? They will make a motion to strike and they will say Amber Heard has not entered into the record in this court evidence of a principal-agent relationship between Johnny Depp and Adam Waldman. And the judge should rule as a matter of law that there is no question of material fact for the jury to resolve in this matter. They should also argue that Amber Heard has not sufficiently pled and put into the record damages. These are the same parts of the same motion to strike. Those two elements are completely missing from this, in my opinion. Now, her case isn't done. They could have some other way to bring it in, but that if they rested right now, this is the argument. Now, the judge probably will not strike the claim. Okay, I want everybody to understand. I need to be very crystal clear because people often misunderstand what could happen as to what will happen. What I think legally should happen as to what legally does happen or practically does happen. I think this judge has ruled very conservatively throughout the entire case, and she wants this highly public thing to go to a jury and not be handled by a judge. I think it is unlikely that the judge will strike this counterclaim based on that fact alone. I fully believe that at this point, Amber Heard has not entered any evidence that Adam Waldman was acting as an agent for Johnny Depp. And I fully believe that at this point, Amber Heard has not properly alleged any damages from those statements made by Adam Waldman because she kept all of her contracts. No contracts were reduced. She says she had to, quote unquote, fight to keep Aquaman or Aquaman 2, but no details as to why. No letters or testimony or anything has been presented that she was dropped and then came back. No renegotiated contracts, nothing at all other than I had to fight to keep it, which we don't know what that means. So her L'Oreal contract still exists. Her Aquaman 2 contract still exists. The only damage that's been alleged came from her agent about an unnamed movie project with an unnamed director and an unnamed actor for no named amount of money. That's not a fact. That's a conclusory allegation that something existed, but that's not a fact that was put into evidence. The agent even said, I could find it, but she never does for whatever reason. Find the name of this movie or the name of this director or the name of this actor who definitely really wanted to work with Amber Heard, probably because he thought there'd be a nude scene. But anyway, so since they don't have those facts, I would make the argument that they have not put these before the court. Therefore, they don't meet the elements of defamation. Therefore, the claim should be stricken. I don't think the judge will do that, but she should do that unless they bring forth some better testimony and properly allege what happened, right? Like that would be the caveat if something else comes in. But that's how we know that this hasn't happened at this point, because she hasn't even rested. So the motion to strike and remove this from the jury entirely isn't before the court yet. Since the motion isn't before the court, we're not going to get a ruling. So